The Dan Yorke State of Mind program is brought to you in part by Lookout Rhode Island and Takeo Comfort Solutions.
Good evening. I am Dan Yorke, and welcome to my State of Mind. The two gyms that wouldn't close, Maxx Fitness Centers in Warren and Lincoln, owned by one gentleman, Matt D'Amico, who resides in Connecticut, came up on Friday in Superior Court in front of Judge Melissa Long. The state of Rhode Island, feeling like the dam was going to break under the pause from Governor Gina Raimondo, rushed in to close those gyms. And after a hearing that was pretty interesting on constitutional and the story level itself, the judge went the state's way. Here's the report from 12 News, and then we'll talk to State Representative Blake Filippi, the House Minority Leader and a lawyer, about the ramifications of the case.
The governor said shut it down, and today they did.
I think it's frustrating.
It's kind of a bummer.
Maxx Fitness refused to shut its doors, claiming nothing they do is a threat to the public.
How could all the studies show that health and exercise help in a fight against COVID, yet we're in a health pandemic and you want to shut down fitness centers?
But the Rhode Island Department of Health begged to differ. In a hearing Friday, the DOH says hospitals are full and the health system is crashing. And if Maxx Fitness stayed open, they were afraid other businesses would rebel too.
We make choices. We can make choices to stay inside. We can make choices to go and to other people's businesses. And
I feel like the gym isn't really any different than other businesses that are allowed to stay open.
When the clock struck 9, these gym doors closed for the next 10 days.
Kind of worried that they're going to go out of business.
And people being cooped up inside, that can really mess with their head, and getting to the gym, you can really get that out.
Gym goers think there are other options.
Maybe lower the capacity a little bit, make sure everyone's being socially distanced.
Maybe like making appointments to come in so that they know how many people are going to be in at a time. Maybe decreasing the amount of people allowed in each area at a time.
The hope is that on December 14th, they can reopen for business, but they aren't holding their breath.
I could be proven to be a prophet.
And so a key guy to talk to about this case, a lawyer, the Republican minority leader in the House of Representatives, and an observer of all things state and COVID, Blake Filippi, joins me this evening, looking dapper for tonight's show, ready, willing, and able to get out into the workforce on a Monday morning as we record this for Monday night. Thank you for joining me. Good to see you.
Good to see you, Dan.
So that story, that package that we just ran gave you the highlights, but based on a conversation that you and I had on the radio on Friday, this is a pretty deep conversation. It's probably two-tiered if I get a grasp of this, and I've been pretty close to it, following it from Jump Street. So Maxx Fitness Centers in Warren and Lincoln refused to adhere to the governor's pause, and the state ran in thinking the dam could break. If he doesn't have to abide, then all heck could break loose, not just with gyms, but across the business spectrum of those at least affected by the pause or mitigated by the pause. So the state runs in and makes the arguments. And it seems like the case broke down in front of Judge Melissa Long in a couple of ways. One, there's the constitutional statutory authority of the governor, whatever she decides in the pause or period, COVID. And then there's the actual meat of the argument as to whether it's fair for the gyms to be identified as a closing business. Falls into that arbitrary and capricious type of conversation. So let's take it in two different places, because you, as a sharp lawyer and a guy who's been trying to get the General Assembly into business for the better part of 2020, have a perspective on both. Let me set this premise. That the General Assembly has been asleep at the switch is very much a part of this case, isn't it?
Correct.
Talk to me about that.
So really, the question is, should we still be in a state of emergency where the governor can exercise legislative authority? My opinion is that when the legislature can safely meet, as we've proven that we can, at that point, there's no longer a need for the governor to be able to exercise legislative authority, that we may be in a state of emergency, but not to such a degree that the legislature's powers are still transferred to the governor. I think that they should be pulled back because the legislature is able to safely legislate and the governor doesn't need to exercise that power.
Now, this is something that you and I have talked about on at least a half a dozen occasions over the course of 2020, and this has got something to do, but it's a much bigger conversation than the gyms. This is a conversation about the state of Rhode Island and everything that's been in play, and we've been hammering over the idea that we really have created an autonomous form of government. So before we get into the details of the case, I mean, in general, this governor, to everybody's clear view, is governing from a microphone at the Veterans Auditorium once a week. Obviously, there's work being done by the time she gets to the microphone, but she's dictating from that place, in part because I think she enjoys the authorization, but certainly by permission of the General Assembly. And there was no effort all year to slow it down, ever.
I mean, you almost can't blame her. The General Assembly has essentially walked off the field, and she's left there with this power. And I'm sure she says, oh, this is nice, but you almost can't blame her for saying, if I'm going to be the only one governing, I might as well govern. I don't believe we should be governed by executive authority. I believe that at most we should be governed by the executive branch's rule-making authority. The problem is that rule-making authority, they're limited to 180 days for emergency regulations. So I see really two ways that the governor can come in and attempt to regulate. One is just through executive order dictates. The other is through emergency rules through the Department of Health. But those are limited to 180 days, and we're past 180 days. And so the governor has come in and used her executive authority and issued an executive order removing the limits on her emergency powers, saying that the rules passed by the Department of Health, the emergency rules, are not subject to that statutory limit of 180 days. Kind of a circular argument, to be honest, but
it's fascinating. I don't think a lot of people have followed the intricacy of what you just talked about. And again, this comes down to the case as well. So Attorney Charles Calenda for Matt D'Amico, owner of Maxx Fitness Gyms, made some of these arguments. And you think as this case forwards to December 14th for a longer injunctive hearing where witnesses can be called and the like, that this may be picked apart for some, really something to chew on in defense of the gyms and other businesses that have a problem with the governor's orders. And that is that the governor herself issued an executive order affecting the very foundational authorization legislation that gives her the autonomy. In other words, she acted inside the donut, sort of, in order to be able to, she filled the hole in the donut by saying, hey, listen, I'm now going to act on whether the legislature can authorize me to act.
yeah, the legislature said during an emergency here, you have all these powers, but we're going to put speed bumps or roadblocks on those powers. And the governor used those powers that were given to her to remove the roadblocks through executive order.
Right.
So I think there's a lot of problems, and everything we just spoke about are legal issues. And then if the governor wins those legal issues, the next step is whether there's the executive order and regulations are arbitrary and capricious. And that's what the witnesses will be called for.
Yeah, well, I should remind everybody that this case, while it was the gyms were ordered closed and they complied on Friday night, a temporary restraining order, there's an injunctive hearing, meaning a longer trial, if you will, on this thing on December 14th. Interestingly, that's the day after the pause is supposed to end. There's a lot to this. So when we come back, we'll talk about how that case possibly may meet out. But then there's the secondary part of it, which is the actual argument about whether a gym ought to be closed versus other businesses. We'll be right back with Minority Leader Blake FIlippi on My State. Please. With Representative Blake FIlippi, Minority Leader in our state house, meaning the top Republican in the House of Representatives, the case that we're talking about, the gyms having to close under Judge Melissa Long's temporary restraining order issued successfully for the state of Rhode Island on Friday, the case becomes hugely precedent-setting if it goes the gym's way, which I think is part of the built-in pressure that the judge felt on Friday. Meaning, not only do we have the constitutional and statutory executive authority arguments that the governor faces from the opposition, still appearing in a couple of weeks, you've got the decision as to whether it's just fair or scientifically appropriate to close gyms based on close proximity, people sweating, all the things that the governor and the health department cite. Two things. The authority of a governor was under the white light, Blake, and then the discretion of a gym, being forced to open or close was precedent setting. Judge Long had a lot of pressure on her. It might have been a one gym state hearing, but it would have been national news if she forced this, or if she refused the state's order. It would have been all over Kingdom Come on both the decision on the gym and then the governing issue. Talk to me about both of those things.
Yeah, I like to think that our judges are immune from pressure, but I don't really know this judge well, but she's highly respected. And I think that, you come in on an emergency basis. I would have been surprised if she sided with the defendant. I think there's a lot of meat she has to dig through, a lot of legal arguments she has to dig through, facts she has to dig through. And I can understand that she said at this point, I'm not prepared to allow this gym to stay open because the ripple effect would have gone to every business in the state. So I think it was actually reasonable that she said, I'm going to need 2 weeks and I'm going to need a hearing. Unfortunately.
At the same time, this whole temporary restraining order issuance is highly dependent on the likelihood of that decision being held up in an injunctive trial. An injunctive hearing, a longer analysis. So it can flip the other direction, based on testimony and development or further consideration, I guess. But those restraining orders are not issued lickety split unless there's a feeling that the state would prevail long term, right? Sure.
So you remember there's a multi-part test. It's the likelihood of success. And this is to issue a preliminary injunction, the likelihood of success on the merits, balancing the equities, maintaining the status quo. So there's more than just likelihood of success. I really think that those other elements played a large role here, in that Judge Long knew that if she denied the state's motion for a temporary restraining order, then everything would have opened up. And I don't think she was prepared at that point. I think she wants to rely on the experts. The problem we have, and we've been saying this for a long time, Dan, is that in emergency situations, really the check and balance is the legislature. If you look at our emergency statutes that the governor is operating under, it specifically says that it's the General Assembly's job to pull us out of the emergency. It's not the judge's job. Obviously, the court can come in when there's been a violation of law or a violation of the Constitution. She can come in, and the court can come in and remedy that. So that's the initial threshold question. But when we get to the facts, whether this is arbitrary and capricious, it's a very low standard that the state has to meet. It's basically a rational basis. Is there a rational basis for the decision? Yes, the decision stands until the legislature comes in and removes the state of emergency.
Well, what's interesting is that the defense attorney, Glenda, for Mr. D'Amico and Jim's, argued that the General Assembly's abdication of responsibility put the judicial branch, the third branch of government, into a place to be more aggressive, to be able to say, look, yeah, what Blake FIlippi just said is absolutely accurate and true, but this is outrageous and unprecedented that the General Assembly would have such a limited role under this emergency authority. So, Judge, can you come in and balance that by acting on the governor's authority, which has been way too longly extended? I get the argument. It's right. Normally, the judge doesn't want to get in and create law. the judge evaluates law. But because the place that creates the law is like this, it's
well. I mean, here's the counter argument: the General Assembly has chosen not to act because they're happy with the way things are going. The counter argument is the General Assembly has acted. It's chosen not to remove the state of emergency because they're happy with the way the governor is operating under the statute and doesn't believe that we need to change things.
I'm reminding everybody, though, that Representative Filippi, Minority Leader Filippi here, is now, acting instinctively as the good lawyer that he is, talking about the General Assembly's perspective.
Yeah.
General Assembly, you're not happy with the body's behavior of such.
Yeah, we should be getting to work. I think we should be looking at the state of emergency or the scope of it, of course. But I think that if the governor can lawfully act, and that's the legal question, they get by that legal question. The arbitrary and capricious standard, it's so hard to meet. It's just so hard to meet.
Meaning judging the governor's judgment about whether a gym should open versus a coffee shop or a physical therapy place versus a dentist office, that it's so hard to argue that she's acted incorrectly. That discretion is hers.
Exactly. And that's from a legal perspective. Now, from a political perspective, just kind of gaming this out, the governor was telling us for the past several months that it's not businesses, it's not gyms, it's not restaurants, it's in-person gatherings that are the problem here. I understand, like, why are we having restaurants but not gyms? I want restaurants open, I want gyms open, I want them to do it safely, but politically, I think there's a lot of questions out there as to whether this is the right decision. Will the court wade into that? I don't think the court's going to wade into it.
No, but and to your point, what I said on Friday is, look, if you're really upset at the judge, then call your rep, right? Then call your rep or senator to get back in and to step on the governor's authority. That's the remedy, it seems.
Yeah.
I don't think people are conditioned right now because everyone's been in a fetal position for all of 2020 to really remember, oh, yeah, it's not just Jeter, right? It's not just Jeter running this whole thing.
Yeah, and it's not to say that, my position is I think the governor can lawfully come in and dictate all these aspects of your life. The governor can't violate law or constitution. And I think I said on your show on Friday, we have to remember that some of the governor's executive orders arguably violate constitutional rights. And I think those are the stronger arguments. And those are the freedom to associate and the freedom to go to a family member's house or to have people over your house. I mean, those are fundamental First Amendment freedoms that the governor is purporting to regulate. And those arguments are outstanding no matter what happens in this case, because this case has been regulated through the government's essential ability to control businesses and how businesses operate. I don't think it translates to that the governor and the government can control your personal decisions, your non-commercial decisions. If I wanted to come to Dan's house for Christmas Eve, I don't think they can.
No, at the same time, and there's the bully pulpit of listen, follow the rules. I think her strategy has been not a good one. She wonders why the curve is exploded into this, leading infection rate. I think we've got a burnout factor here. I think there are a lot of folks that just stop telling me what to do. It'd be nice if you asked every once in a while. It very well may have affected the way people think. There is a tiny little, only in Rhode Island part of this case, though. We'll have a quick discussion on that when we come back. Representative Blake Filippi, Blake, it's always interesting. There's always another chapter of my Only in Rhode Island book. So Judge Melissa Long had the Superior Court trial date for this temporary restraining order case with the gyms that were looking to stay open in the state, moving against them. She is a top pick from the group of finalists the governor considered to nominate to the Supreme Court. So there are a lot of folks thinking, what are the chances that this judge is going to rule against Governor Raimondo while Governor Raimondo has got her Supreme Court nomination in her hand? One would hope that that's not germane, but it's just another one of those Rhode Island coincidences. You have a thought on the legislature? I only have a minute. You have a thought on on any of that?
Yeah, I'll go back to your prior comment. You're saying people are losing buy-in here. We've been saying people will lose buy-in because the proper government structures aren't being respected, i.e. the General Assembly has gone home and given all power to the governor. I think that has caused people to lose faith in the system and the rules. So if the General Assembly did its job, I think the governor's job would be much easier. As to Judge Long, she's highly respected. I like to think that all judges are independent. They know their roles, and until there's some evidence that there was improper influence, I wouldn't even go down that road. She's highly respected and a great judge.
You have to raise the objection to calm the objection. I thought that she actually gave a pretty long alliteration about her rationale for holding up the Trump, for granting the restraining order. And it was based on law and science and the like. So it's not like she gave a flip answer to the whole thing.
Yeah. They barred the courthouse.
Right, exactly. I got a few seconds here. When does the General Assembly take the reins back? Yes.
I don't know. I mean, we're conducting oversight now under presumptive Speaker Sakarchi, and that's a lot more than we ever got out of the prior speaker. So, I mean, I'm hopeful. I think things are changing. I don't know. I know we're going back into session next week to deal with the budget and potentially the Supreme Court picks.
A feeling on when emergency authorization will be withdrawn?
I don't know, Dan. I mean, certainly there's going to be a lot of legislation that deal with our emergency statutes coming up. Republicans have a real suite of reforms to the way we do emergencies. That's going to be taken up, and maybe if those bills pass and we haven't come out of an emergency, the governor's powers under an emergency will be limited.
Time will tell. My guess is the pause ain't 2 weeks.
Yeah.
Wear your masks. Wash your hands. Keep your distance. Blake, thank you. Final word and we come back. Stay with us. This case of the gyms open or closed under the pause has a lot to do with a lot more than just the gyms, and we'll continue to pay close attention to it. Talk to you on the radio, 3 to 6 on WPRO, and back here tomorrow night. Thanks for tuning in.